Hey everyone, welcome back to another video. I hope you're all doing well. Today, we're breaking down a courtroom sentencing hearing involving serious crimes against a child and the legal consequences that follow. As the hearing begins, the judge makes it clear that every detail has been carefully reviewed. Miss Bergman has been convicted of 3 felony offenses involving a child, including child enticement under Statute 948.07. Under the law, this charge alone carries a maximum possible sentence of 25 years, with up to 15 years of incarceration and 10 years of extended supervision. How will the court weigh the seriousness of these convictions when deciding what punishment is appropriate?
We also have 2 counts, I think 6 and 8, and the first one was count 3. 6 and 8 of sexual misconduct by a school staff person under 948.098. And as Mr. Tamburino learned in his research, it's a relatively new statute that was passed, only became effective early last year. And so there are not many cases. That is, the penalty associated with that is 3.5 years total for each, with incarceration maximum of 1.5 years and extended supervision of 2 years. Now let's talk a little bit about the gravity of these offenses. And I think, and I don't want to minimize the fact, and I accept that we have also dismissed and read in a number of other charges, some very significant charges, and I've taken those into account here today. But I want to focus on the 3 felonies for which Ms. Bergman has been convicted, and the gravity of those offenses. The gravity really arises out of, in many ways, the victim and the circumstance of the victimization. That is, a 5th grader and his teacher. That's the source of the gravity to me. And, you know, we've got differing charges. Obviously, child enticement, a much more serious charge in terms of, you know, alleging sexual contact intent. And we've got these 2 lesser felonies, and I say lesser in quotes because I don't mean to minimize by any means. But Class I felony and 2 Class I felonies and a Class D felony. But the gravity collectively of all of these charges for which you've now pled guilty are the victim and the consequence to the victim. Beyond that, and I'm going to get into this in a little bit, there is the pervasiveness of the actions. And I think this goes to, and I do have a moment when we'll talk about those other cases, Mr. Tamburino, a few of those, at least generally, in terms of your analysis of sentences for child enticement in this new school staff member charge. This is unique in many ways because of, I think, the age gap is important. I think the position of power, or I think a better word perhaps is trust, is important. And then if you look at the time frame and the pervasiveness of the activity, which I'm going to get into in a minute, the gravity becomes even more apparent in my estimation.
The judge then turns to the seriousness of the offense, noting that its gravity is reflected in the parties' agreement to lifetime sex offender supervision. This level of supervision is not automatic. It must be requested, agreed upon, and supported by specific legal findings. The court confirms that proper notice was given and that, under the statute, such supervision is necessary to protect the public.
That's required. And so it's counterintuitive to me, in a sense, to, on the one hand, say sex offender registration is agreed, and this burden will be with Ms. Bergman for the rest of her life, and at the same time, she poses no risk to the public. So I just offer that. That's a little bit inconsistent in my thinking, but and I'll say one other thing about that. Our Supreme Court has already said that sex offender registration is not punishment. That's why we don't have to offer a warning about sex offender registration being required at the time of plea. And our court has ruled that sex offender registration and that level of supervision is not punishment of the defendant, but it's protection of the public. Okay? Now, is there a very real consequence to the defendant subject to that? Yes, granted. But I just wanted it understood that for my purposes here, our Supreme Court has explained that it's not punishment, though obviously it poses a burden to a defendant. Now, one could easily minimize the gravity of these offenses and make, I think, an effective argument to a limited degree that there was not the level of sexual contact, I think, Mr. Tamburino, that you were talking about in these other cases. And I think that's a fair argument. That, however, has to hold up against the other reality in this case, and that is what happened here. It's not the same. It's not like many of those other cases. It's a different kind of terrible, frankly. Horrible, I think that might be the word that was used. So what do we know about the facts? We have an 11-year-old boy, a 5th grader, first contact with the defendant as a 4th grader, I think. That's what was reflected. The contact, the personal contact is happening in school, and it began to increase during his 5th grade year when Ms. Bergman became his teacher. She was even surprised that he was assigned to her class because there was some concern about them being friends before that 5th grade started. But nonetheless, he was. First message, I should say, emails that exchanged between the two were from November 29 of 23 to October 29 of 23, according to the investigating officer.
Investigators reviewed 34 emails exchanged between the teacher and the student. While none of them were overtly explicit, they were also not related to education or learning. There was no legitimate academic purpose reflected in those messages, a fact that immediately raised concern for investigators reviewing the communication. If these messages were not about school, what was really developing behind the scenes?
Then, a couple of months go by and we get to December 26th of 23 for the first message. And obviously, I didn't go through all the messages. There were 35,000 messages or so. I went through the ones that were provided to me and paged through the exhibit that we had from our original preliminary hearing. But they were provided to me in the PSI, largely and to some degree in the amended complaint. The last message I saw was from about April 29. Total text, 35,429. So between those dates, I did some math, Ms. Otten, and I came up with about 125 days or 283 texts per day. This is ridiculous on its face. Now, I'm a 67-year-old judge, so I may not text like some, But this level of contact between a 24-year-old teacher and an 11-year-old student going to an elementary school here in Hudson is unbelievable. And then when you start reading what's in the text, we've seen a lot of the details. I don't want to go through that, but I do want to just list off some of the topics that were discussed over time that I identified. Touching each other, kissing, pushing against each other, touching the victim's chest, feeling heart beating, physical characteristics of each other, dreaming about each other, female sexual arousal, female menstruation, devices used for sexual arousal, oral sex, use of fingers to achieve sexual arousal, licking, body parts, touching, victim's stomach, the victim's own sexual arousal, touching legs, expressions of love. I'm so in love with you. I see you in the morning and I get wet. This is crazy, in a sense. And so when I listen to the arguments here, and then I look at the actual text, and I'll get to this in a moment, I'm left with this sense of deliberate purpose and process over time. Because I can see in my review, and I didn't read 35,000 texts. I read a few hundred probably. But what I saw there was the salacious content started with Ms. Bergman. Now, the victim would respond, perhaps learning, engaging, and all of that as an 11-year-old might. But these very crude, inappropriate, lurid details generally started with Ms. Bergman. That's disturbing. So I say that all by way of understanding what the gravity of the offenses are here today. Let's talk about protecting the public for a moment. And this is important in two contexts. First of all, because it's an important factor that we have to discuss in any sense, as we look for the best means to protect the public from that kind of thing happening again to this victim or any other victim in our community.
The court explains that protecting the public is a critical factor in sentencing decisions. When incarceration is necessary to prevent future harm, it weighs heavily in favor of a prison sentence. Based on a careful review of the case file, the judge emphasizes that this consideration cannot be ignored.
We simply do not understand the source of this behavior from Ms. Bergman. At least I don't. I don't know why it happened. I'm going to talk in a little bit here when I get to talking about the defendant herself and her response to all this. We'll talk a little bit about that. I don't know why she did this, why she did it for so long, why she continued to bring up new and more salacious details to talk about with an 11-year-old boy. I don't know what level of supervision would be necessary to prevent her from doing this again. We have varying opinions about the need for incarceration, about as varied as they can be. 12 years, 1 year. But I will say this, for purposes of my conclusions here today, I do believe incarceration in the Wisconsin prison system is necessary. to protect the public. So I will tell you that I am not inclined to withhold sentence and place you on probation at this time. We'll get to the details. There's more to come. I just want you to understand, I do believe that there is a level of protection of the public that's necessary. And I say that, let me just say one last thing about that for a moment. And I say that because I think there needs to be some in-custody distance between Ms. Bergman and these events. And I think that will be a positive for the community, and ultimately, frankly, I think it will be for Ms. Bergman as well, though I know she doesn't agree with me on that. Now, let's say a few more uplifting things from the defendant's point of view. I want to talk about the defendant for a moment, specifically. You don't have a criminal history, okay? And that's to your credit. And I don't want to minimize that, because I think that's important when it comes to a determination of what the ultimate sentence is. You didn't have any trouble on bond. You did what you needed to do. We even, as Mr. Gambarino said, we modified bond. I think we took the GPS off after a period of time, and that was positive as well. I think that you demonstrated that you can be in the community and follow the court's orders. You've been engaging in rehabilitative efforts. That's to your credit too. Okay? Whether it's in custody or out of custody, and I think that's a positive. And I've looked at some of the medical records, I've looked at the psychosexual evaluation and what that talks about as well.
The judge then addresses the defendant's response to the charges. Some positive aspects are acknowledged, including expressions of remorse and formal apologies. The court recognizes these statements as relevant when weighing the overall sentencing decision. But how much weight should remorse carry when measured against the seriousness of the conduct?
In terms of the PSI, though, I am a little bit concerned, and this is what gives me concern in terms of the need for incarceration and the need for a more advanced approach than perhaps Mr. Gambarino is advocating. When I look at the PSI, first of all, with regard to the text messages, I think it's clear, while this was going on, while you were engaging in this activity, you knew it was wrong, you knew you should stop, and you knew that there were legal consequences up to and including jail that could result. Text messages talk about that. So that whole idea of continuing to engage in this criminal conduct while recognizing what you were doing was criminal conduct, while it was affecting the victim, that doesn't go to your credit. And then, in looking, starting on page 17 of the amended PSI, we look at, and I just want to read some of this. Essentially, what happened was the PSI writer read a whole bunch of the text to you, and you sort of responded to, you know, what do you think of that? And the PSI writer says, Ms. Bergman reported all of the things she and E.H. said to each other in their text messages did not actually happen. She said they pretended those things did happen, but she was texting the victim on how she wanted her significant other, I'm not going to use the name here, to be with her. The defendant indicated she dissociated when she texted the victim and was thinking of an adult, specifically the fiance, when she sent the victim messages. Ms. Bergman stated the messages were things she wanted the fiance to do to her and how she wanted the fiance to act toward her. The defendant reported the sexual contact that she and the victim discussed in their messages did not occur. She stated they kissed each other only on the cheek and were creating a fantasy in their messages. Right after reading the text to you, or some portion of the text, obviously, the PSI writer says, the defendant indicated she does not remember sending them and felt lost and isolated from her family at the time. She stated she was looking to feel wanted and was not getting that from her fiance. Ms. Bergman says she's not sure how this situation with the victim occurred and would never say any of these things she said to him to someone her own age. The defendant reported she felt stupid and like a pushover at the time, but the victim told her it was not a big deal and to keep exchanging messages with him. Now this is all completely backwards. The adult in the room is telling the PSI writer that, you know, I was kind of a pushover to the 11-year-old. So I kept texting, I kept messaging, I kept talking about inappropriate things. Anyway, I just wanted to express my concern about this sort of devolving into fantasy situation when it comes to deliberate, specific, sexualized texts for months, hundreds of times a day to an 11-year-old boy. It's a fantasy, and I was thinking about my fiance, not good enough. The last thing I'll say about that was, you know, when I was reading those texts, honestly, I couldn't tell who the 11-year-old was sometimes. I know that sounds crazy, but both sides of the text messaging seemed like an 11-year-old in the behavior that was going on there. The sheer quantity and lurid content of the defendant's text belie any concern for the victim. Her position of trust, her school, her community. It was intentional, deliberate, purposeful. What was the end game? And I think Ms. Otten alluded to this. Where were we going with this?
The judge makes clear that, while the conduct already proven is extremely serious, the evidence suggests it could have escalated further if it had not been stopped by the parents. The court notes that the prolonged messaging shows an exercise of control by a 24-year-old adult who knew her actions were wrong, yet continued for months despite that awareness.
Now, we have to talk about the victim, as we should. And, you know, I was struck here today by what Dad had to say, and that was very immediate, very specific. And I was also struck by the letter, but I balanced that with Mom's comments about, you know, jail isn't the answer. And I think that's probably a fair, that somebody may approach this and say, I don't care about jail. And somebody else might look at it, another victim or member of the family might say, it ought to be a whole lot of jail, a whole lot of prison. And I understand that. And I don't find it inconsistent, I just find it's a different point of view. Different people with a different point of view. But this whole process, everything that happened since this began in December of 23, has been devastating to the victim, life-changing to that young boy. And we saw how, you think back on when you were 11 or 12 years old and going to school, and how hard it was anyway. And now, what about this? There's stories about this, for heaven's sakes, in London newspapers. Imagine how devastating that would be. That's not to say that people should, that Ms. Bergman is responsible for that in the specifics of how far this goes. I'm not saying that. I'm just saying that's the world we live in. And the salacious nature of this particular set of crimes brought attention. And that attention creates greater trouble for the victim and the family and our community and the school system. So, I am very disturbed about the impact on the victim. Now there's an element of sentencing that we haven't talked about here today. You didn't bring up. That I think is very important. I'm going to spend a couple of minutes on it. It's called deterrence. Deterrence is a proper purpose of sentencing. Because we have here before us 3 felony crimes from someone in a position of trust in our community here that deserves us considering what is an appropriate sentence to be certain that we send a message from this bench here today that this kind of behavior is not tolerated in our community and in our state. 35,000 texts, 283 a day, a level of emotional control and sexual contact that is offensive. A breach of trust to the student, to the students at that little elementary school, to the faculty at that school, to the parents, to our entire community. It's just hard to imagine the scope of the aftermath in this age of instant media, whether it's press or social media. And what does that do? Parents have to be confident that their teachers are doing the right thing. They have to, because they entrust their kids to pick the teachers every day. And when these kind of events happen, parents start to wonder. I wonder what else is going on. Conspiracy theories abound. All of that happens. And so sentencing in this case does involve a certain measure of considering what will deter this from happening in the future. Because we as a community, our school district and the school districts in the state cannot afford to let this kind of thing happen, at least to the degree it's within our power. There's another factor in sentencing that was mentioned only briefly, and that is punishment. Punishment is a legitimate factor that's mentioned in Galleon, and not without, it's an important consideration here too. Because as we look at, and I think, Mr. Tamburino, you made very good arguments about the rehabilitative services outside of incarceration, about your client's ability to be in the community and perhaps the public can be safe. At the same time, we also have to recognize that for certain crimes, certain punishment is appropriate. And this is one of those cases where I think some punishment, as I said, in the state prison system is appropriate. So now let's talk about the prison factors, because we must. And that is confinement necessary to protect the public in this case? And I do believe for a time it will be. And to Ms. Otten's point, probation in this case would unduly depreciate the seriousness of these offenses in a way that I haven't often.
After weighing all the factors, the judge states that this is a case where a prison sentence is necessary. At the same time, the court explains that the sentence requested by the state goes beyond what is appropriate under the circumstances, requiring a balanced and measured decision. How does a court draw the line between accountability and excess in a case like this?
I don't offer that as criticism. I just offer that as my opinion based upon hearing everything here today. I think that we've got to balance, as I look at some of those cases that Mr. Camberino pointed out, the enticement cases and other cases. While we are here today and are extremely frustrated and concerned about these facts and this case and the terrible impact that it's had, I also have to be mindful that there are cases even more extreme with defendants who have long records of that kind of behavior. And in that light, I think that a more appropriate sentence, and the sentence that I will hand down here today, is I'm going to order that Ms. Bergman be incarcerated in the Wisconsin State Prison System for 6 years. And that she serve 6 years on extended supervision thereafter. That's on count 3. With regard to counts 6 and 8, I'm going to order 1.5 years of incarceration on each. That's the maximum sentence. And 2 years of extended supervision on each. And I am going to run all of this concurrently. I think essentially the outcome here is 6 years in the state prison, 6 years of extended supervision is an appropriate sentence given everything I've heard here today, everything I've discussed with you. Now, Ms. Bergman, you're going to have to calm down for a minute because I have to give you some more. All right. Now, first of all, with regard to lifetime supervision of serious sex offenders, and the first charge for which she's been convicted under for child enticement is eligible for serious sex offender lifetime supervision. The parties have agreed to this, but I still need to make some findings for it to be legal. 1, proper notice was given under 973.125 in the form of a pre-arraignment complaint so that the defendant was on notice that this was being requested by the state. Secondly, I do find and continue to find that this level of supervision is necessary to protect the public. The reason I say that is, frankly, and once again, I don't know what made you do what you did. And so therefore, I believe that the public needs the protection. And frankly, the parties have agreed with me on this point. We also have a warning that I need to give you with regard to being convicted of a serious child sexual offense. So, because you are convicted of a serious child sex offense, it will be a crime punishable by a fine of $25,000 and 12.5 years of imprisonment or both if you engage in an occupation or participate in a volunteer position that requires you to work or interact primarily and directly with children under the age of 16. You are advised that the following is a prima facie evidence list of the occupations or volunteer positions that require you to work primarily and directly with children under the age of 16. This is not a comprehensive list. This is just the list they put in the statute as examples. Teaching children, child care, youth counseling, youth organization, parks or playground recreation, and school bus driving. Do you understand all of that?
Yes.
As part of the sentence, the court orders the defendant to comply with Wisconsin's sex offender registration requirements for the rest of her life. The judge also issues mandatory warnings, including a permanent prohibition on possessing firearms,
Yes, Your Honor,
making clear that these conditions are legally required and strictly enforced. What does lifelong registration mean for someone once the sentence is imposed?
Your civil rights, you can't vote or hold public office until your civil rights are restored. Any other warnings we haven't addressed that I think might be appropriate?
I don't believe so, Your Honor.
All right. Now, what do we have for jail credit?
I believe they're, is it 92? No. I thought there was 87 or 89, Your Honor.
So here's what we normally do if you don't know for sure. I'll give you a week for one of you to send me a letter telling me for sure what you agree the jail credit is. That way you get it right, and then I'll just order the clerk to amend the judgment to reflect the jail credit. Does that work for the state?
That works, Your Honor.
Mr. Tamburino?
Yes, Your Honor.
All right. Let me look at my list. Do we have any restitution requests? I haven't heard anything about restitution.
Not to our knowledge, Your Honor.
All right. So we have to assess costs. We have 3 felonies here, and we'll order minimum costs. $268 of costs per felony. So that's $268 times 3. Plus $250 for the DNA surcharge times 3. I'm just going to order collection through the Department of Corrections on extended supervision. There will be, they may try to collect some of that through any kind of prison receipts that you have, but I don't have any control over that. That's done by the Department of Corrections.
Your Honor, we do have a large cash.
Oh, we have cash bond, okay. Let's take a look.
That's correct.
She's in custody now, but what have we got? 25,000? All right. So all that will get paid, and then once that has been paid, the balance of the bond will go back to whoever paid. Okay? You'll have to have your DNA taken. They'll take care of that in custody. And we need to talk about conditions of extended supervision. That's the one thing we haven't talked about. So, have you had a chance to look at the conditions in the PSI, Mr. Tamburino?
Yes, Your Honor, I believe it's on page
Very end of the...
36.
I found all those conditions to be appropriate and suitable. Basically, there's no contact with the victim and the victim's family. No contact with anyone under the age of 18 without prior agent approval once you're released. Complete a sex offender sexual deviancy evaluation and follow through with any treatment or recommendations. I am going to say that if at the time that that's done, that prior work can substitute for redoing the work, I'm going to leave that to the discretion of the agent to determine whether or not I know you've had a psychosexual evaluation, you've been undergoing some treatment, And so I'm not going to require that it all start over. I'm going to leave that to the agent's discretion. You'll comply with any programming recommended by the Compass Assessment and the Department of Corrections. You can't use the internet and any forms of social media without prior agent approval. You need to comply with the Wisconsin Sex Offender Registry program requirements. And we've already covered court costs. So I think we've done that. You are not eligible for the challenge incarceration program or the substance abuse program, and that will be reflected on the judgment of conviction as well. I do think that I've come to the end of my list, other than appeal rights. Is there anything, Ms. Otten, that you think we haven't addressed?
I believe we have it all covered, Your Honor.
Mr. Tamburino?
Agreed.
You have 20 days to appeal the decision of this court with regard to your sentence. Your attorney will go through a form with you that will describe your rights. You'll be able to make a selection on the form, and that will get turned into the clerk. For now, you are remanded back into the custody of the St. Croix County Sheriff for delivery to the Wisconsin State Prison System in due course to serve the sentence of this court. We are adjourned.
That wraps up today's coverage of the sentencing in this serious case. The court has outlined the defendant's sentence, supervision requirements, and all conditions to ensure justice and public safety. We'll continue to follow this story as it progresses. If you found this video informative, make sure to like, comment, and subscribe for more courtroom updates, trial coverage, and legal analysis. Hit the notification bell so you don't miss any future videos. Thanks for watching, and we'll see you in the next one.